Hello, wonderful people. Happy good afternoon to you guys. Happy to come your way. Today, I want to discuss a very, very important and exciting topic. I'm just live on Facebook, so I hope Facebook has joined. Um, Maybe I should have added Instagram, but Instagram, the connection can sometimes, be very unstable. So I'll record here on Facebook and then we will repost on Instagram, and then I'll try to go live on Instagram maybe by go live on Instagram alone on that platform alone and see what happens. Okay, I see you guys tripping in. Welcome. Happy Thursday to you guys. Drop me a comment. Today we're talking about something really important. We're going to be talking about waivers, non-immigrant waivers. It's something I see really common. A lot of immigrants are told that they are inadmissible. They go to the U.S. embassy in their countries, or even they get to the airport and they are told they are simply inadmissible. So that means that they cannot be granted any visa or any type of immigrant visa or even a student visa or visitor's visa. If you are inadmissible to the United States, it means you cannot be allowed to come to the US. You cannot be granted a visa. You cannot be granted admission. So it means you are simply barred from entering the US. Okay, guys, welcome to this live video. If you're watching on YouTube later, subscribe, like, comment, share. And of course, if you're watching on Facebook, please like the page, turn on your notification buttons, please, so that you will know when we go on live. Okay, so we're talking about inadmissibility and what to do if you have been found inadmissible. I see it a lot with Ghanaians and Nigerians, and of course, other African countries. What happens is that some people have been given, maybe some people want to come visit the US, or some people have been given admission to schools in the US, or they just need to come to the US for some purpose. They go to the embassy and they're told you are inadmissible, meaning you've been denied the visa. What can you do? Remember, inadmissibility, it can mean that you're permanently barred from entering the US until and unless you seek or you file a waiver. So when you are barred, for example, or you are inadmissible under Section 212A6CI of the Immigration and Nationality Act, that's the misrepresentation and fraud inadmissibility ground. It's a permanent waiver, and until you it's a permanent ground of inadmissibility, and until you file a waiver, you will not be getting a visa, not now, not anytime in the future. And so people find they keep going and they keep getting denied. Until you file a waiver, you will forever be denied a visa and you cannot enter the United States. So without a waiver, it's simply impossible if you have been found inadmissible, especially based on certain grounds of inadmissibility. Some grounds of inadmissibility are not waivable, for example, espionage or terrorism and all those things, but for security reasons. But grounds like for today, we'll be focusing specifically on the 212A6CI. That's the ground of misrepresentation and fraud. It's one of the very common grounds. So that's what we're going to be discussing, and I'm going to be telling you, what they look out for when you file a waiver. What are the arguments we present to the ARO? That's the Admissibility Review Office, which is based right here in Hendon, Virginia, just about I would say 30 minutes away from me. So of course, when you file the waiver at the consulate, then it will be transferred to the ARO here in Hendon, Virginia. And then, they will take a look at your waiver, see if it passes muster, and then for the decision, and then you can be granted your visa or your immigrant visa or your or whatever you're seeking, can be granted despite your inadmissibility based on, let's say, misrepresentation or fraud. Okay, so we're going to be looking at the case, the basis of this. So that if you're filing, so let me distinguish. There's a difference between immigrant visas and non-immigrant visas. So immigrant visa means that you want to come here and live permanently in the US, and so that's when a family member has filed for you, your mother, father, brother, sister, husband, they filed for you, and you're coming through an immigrant visa. So you have to go for the visa at the consulate. That's an immigrant visa. If you are going for a non-immigrant visa, it's a B2 or a B1 visa, it's an F1 visa, it's any other type of visa that means that you're just pretty much coming for very limited or a defined period of time and then you're going back to your home country, it means that it's been defined in law as having a residence abroad and not having the intention to abandon that residence. So remember, those are some of the things you need to demonstrate in order to be eligible for a non-immigrant type of visa. And so when I'm talking, what this Hranka waiver is only for non-immigrant type of visas. This same type of waiver is known as the 212D3 type of waiver. It's the Hranka waiver. It's the non-immigrant waiver. Okay. So this Hranka waiver is based on the case matter of Hranka. It's a case law, and it's now become the name of the waiver that you have to file for for inadmissibility for non-immigrant type of visas. So let's take a look. This case was decided as far back as 1978. It was decided by the Board of Immigration Appeals. Okay, so again, this non-immigrant type of visa, this non-immigrant type of waiver is under section 212D3 of the Immigration and Nationality Act. That's why it's known as the 212D3 waiver. Okay. And here they're going to be looking at three things. When you file this waiver, it will require the balancing or the weighing of three factors. The first is that what is the risk of harm to society if you, the applicant, you're admitted. So let's say, let me use an example. Let's say you went to the embassy you were going for a B2 visa and you took, let's say, let me use one example. Let's say you stated a wrong date of birth. You stated a wrong date of birth, and then they found out that there's a discrepancy between in your date of birth. Maybe one passport had a certain date of birth, and then maybe your birth certificate even had a different date of birth. So they find the discrepancy, and they think that this looks like it was a willful intent to deceive an immigration officer. So they say, okay, you are ineligible based on misrepresentation. Okay, so they'll look at what is the risk of harm to society if you are admitted. They'll look at you, the totality of the circumstances, and see, okay, if Kojo is admitted to the US, is there any type of risk to the US society? The second thing is, what's the seriousness of the applicant's immigration law or criminal law violation? So they look at the seriousness of the violation. So if it's a date of birth, remember, date of birth, places of birth have been defined in immigration law as being crucial to a person's identity. So they'll look at the circumstances surrounding that mistaken date of birth. Was it willful? What happened? How did that happen? You need to explain all that with evidence. Okay. Then the third thing is they'll look at the nature of the applicant's reason for wishing to enter the US. If you're coming for a short visit, or maybe you're coming to school, that's a good reason. So whatever it is, they'll take a look at why you are coming and then decide. So let's look at the case itself. In matter of Hranka, let me scroll down. It was about a Canadian woman who actually came to the US and she was prostituting. And prostitution is against the US laws, and they balanced the factors and realized that they could grant her a non-immigrant type of waiver because she had already missed some of her cousin's weddings, and her mom wrote a very touching affidavit to the BIA. It was like, look, the girl has reformed. She's no longer prostituting. She had actually she was with a certain man who was a bad influence on her. So that's why she actually undertook prostitution, but she's rehabilitated. So please have mercy on her. And based on the three Hranka factors, they decided to waive her inadmissibility ground based on prostitution. Okay, so the applicant, oh yeah, I believe I just highlighted some of the portions of the case. The applicant's mother also stated that her daughter had always been well behaved until the time she began living with a certain man in Detroit. The man had a very negative influence upon her. She began to use heroin, engage in all of this. Okay, so they reviewed that letter and they believed that, okay, this was a good case for waiving her inadmissibility. So pretty much the one other legal principle in the matter of Hranka, or when you're filing a Hranka waiver, is that there's no legal requirement that the reason for wanting to enter the United States needs to be compelling. And that when the woman filed for the visa, I believe that one of the field offices gave the ruling that, oh, her reason is not compelling, there's no compelling reason for her to enter the US. But the Board of Immigration Appeals ruled that it doesn't matter. You don't have to have a compelling reason, and that it doesn't, you can just be coming to have a frolic of your own, to gallivant, to come for a wedding, to visit. Those are not what they're looking for in the matter of Hranka or under the Hranka principle. The essential factors are just three. The first one is that what's the risk of harm if you're admitted? Secondly, what is the seriousness of your prior immigration law or criminal law violation? And thirdly, what's the nature of your reason to enter the United States? So those are the only three things they're looking at when they review your Hranka waiver or your 212D3 waiver. Okay. So it's based on the matter of Hranka, again, which is the 1978 case law that forms the foundation of the non-immigrant type of waiver. Okay, now let's share. I'm going to share the text of the statute under section 212(d)(3). That's what codifies the matter of Hranka. And actually, let me take this off and then let me share this with you. So we'll read the text of the statute so that you see what the law is looking for exactly. Not chapter 4. Okay, right here. No, actually, I believe what we're coming to look at is under 2126CI. Okay, that's what I pulled up. That's what makes you inadmissible under misrepresentation. That's one of the most common grounds of inadmissibility. So it's that under section 212A6CI, it says that misrepresentation, that's the title. Any alien who by fraud, can you guys see it? I think it's a little, the font is a little small. But any alien who by fraud or willfully misrepresenting a material fact seeks to procure or has sought to procure or has procured. They're catching you in with all these variations, well, whether you are seeking to procure, sought to procure, or you have procured, or you attempt to procure. So whatever be the case, they'll catch you somewhere if you make any attempt to do any of these things. So you seek to procure a visa, other documentation, or admission into the United States, or other benefit provided under this chapter is inadmissible. So that's the misrepresentation or fraud ground of inadmissibility. Once you are caught under this very dangerous net, you are in big trouble, and you need a waiver, and it's a Hranka waiver. It's if you're trying to come in through a non-immigrant type of visa. Okay. There's something else I wanted to share with you guys. Let me see if I will find it. I think it's just the fact that this type of waiver is very, very discretionary. So in my next video, we could probably talk about, what's the process for filing this waiver and what happens. Today, I just want to discuss what you can do if you have that bar. If you have the 212A6CI bar, it's a big headache. In fact, this type of waiver is not common at all. There are lots of people that don't even know that there's a type of waiver that's for non-immigrant visas. Some attorneys will tell you there's no waiver for a non-immigrant type of visa, but there actually is. It's not common at all. So note that if somebody tells you that, tell them there actually is. Okay, so let me see, where is it? Right here. Yeah, okay, perfect. So this is the policy manual we're looking at, the USCIS policy manual we're looking at here. They've pretty much repeated the matter of Hranka, and I believe I don't know what chapter, I pulled it up too fast. Okay, so USCIS considers whether the applicant may be eligible for a discretionary waiver under 212D3 if the applicant is ineligible for a waiver under 212D13. No, this is not what I'm looking at. This is not what I'm looking for, actually. I'm looking for... Okay, this is what I want to talk about. The fact that it's a discretionary analysis. It's purely based on discretion, okay? So this waiver is based on discretion. So that INA 212D3 waiver analysis is a purely discretionary determination, and the analysis involves balancing social and humanitarian considerations against adverse factors. Okay, so again, in addition to considering a broad range of discretionary factors, they'll consider these main three things, as specifically outlined by the Board of Immigration Appeals in the Hranka case. Again, the risk of harm to society, if you're admitted, the seriousness of your, a prior immigration law violation or a criminal law violation, and then the reason for wishing to enter the United States. And then in addition to these factors, officers will take into account, should take into account as a positive factor that the applicant has suffered a severe form of human trafficking in presence and has complied with any reasonable law enforcement request for assistance. No. So that's all relevant for our purposes, but pretty much this is a very discretionary type of relief. So if you need assistance with it, please be sure to contact me. Oh my gosh, I don't know why I didn't put a title today. Well, I don't always, but sometimes that helps. Okay, so that's we have it there, the Hranka way. But do you guys have any questions, concerns? Let me see if there's something more I can pull up. We're keeping it short and sweet, guys. I will be reading your comments soon. I see a few comments. And so we'll take a look at those comments very, very soon. Okay, now let me go through this. Yeah, normally you have to remember that if you're filing for, these are some extra considerations. If you're filing for a Hranka waiver, right, it doesn't exist in vacuum. It has to be the foundation of a visa you're applying for, because if you even, after you file the visa and you are inadmissible and you're, because you're inadmissible, you will not be granted the visa. Okay. Again, you could file the Hranka waiver and it could be granted, but you will be ineligible for a visa. So the point is that you need to make sure that you should first of all be eligible for the non-immigrant visa that you are applying for. Then you do the Hranka. You need independent eligibility for the visa as well as independent eligibility for the Hranka waiver. Okay, so that's it. You need to note that you have to be eligible separately and apart from the eligibility criteria under the Hranka. So depending on the type of visa, if it's an F1 visa, you have to be eligible for F1 visa. If it's a B1, B2, you have to be eligible. And then if, for example, is under 212A6CI, you need to talk about what was the misrepresentation about, discuss it. Was it willful? Was it not willful? Was it material? Was there intention to deny, intent to deny? Was there knowledge of the falsity of falsity? All of those things, talk about them. Then we'll also talk about the fact that they're eligible for the waiver. That's when you look at all the factors in the Hranka, and then you actually demonstrate that you're eligible for the Hranka using, proffering very strong arguments and analyzing the Hranka case, and then also using the individual's circumstances to actually make sure that the case is put in a favorable light, and the discretion of the officer will be in the favor of the applicant. It's all in the way you word everything and how skillful you are in kind of arguing your case very nicely. Okay. So guys, let me read some comments and then I will be off. We've done 18 minutes. So I have Peter Kwame Wilson who says he's watching from Ghana. Peter, thank you so much for joining. I appreciate you. Adwalo, oh my gosh, thank you. It's been quite a while. I hope you are doing well. I am very happy to see you live on here today. Thank you for watching. Mr. Francis Garbin, thank you so much. I appreciate you so much. Mr. Francis Garbin says, hi, hello, Mr. Garbin. Okay, you guys, I hope you guys we've had a fruitful session. If you have anybody that needs an amazing immigration attorney, don't forget to recommend me. And the reason I keep saying this is sometimes I hear heartbreaking, very disturbing stories. People go all around seeking legal advice from everyone else but a lawyer, and they're sometimes messed up. Some of the stories I hear on a daily basis are heart-wrenching. They go seeking legal advice from connections and people they think are in high places, but who don't understand, for example, immigration law. In fact, what I want to tell you is, even if you're using a senator's office, remember that a senator's office, the people that, because the senator is not going to follow up on your case. The people that work there, remember, they're not immigration attorneys, so they can assist you and they are very helpful. But even as attorneys, we always work with senators' office, and we sometimes offer them guidance and then work hand in hand with them to make sure that they're bringing you, good resolutions when it has to do with U.S. consulates or U.S. embassies around the world. Please do not go seeking legal advice from people who are not attorneys, or especially people who are not specialized in U.S. immigration law when it has to do with your U.S. immigration law matter. These are very sensitive matters, and you need to have good people who understand what they're doing to assist you to make sure that you get what you need and what you deserve. Okay, guys, remember, good things don't come to good people. They come to those who fight properly for them. So you can be in a fight, just a bogus fight. You're just, look, sometimes you have somebody in front of you and you're busily fighting somebody behind you. The enemy is right in front of you. So that fight is bogus. You'll be very exhausted. You'll be tired. But at the end of the day, it will be a useless fight because nothing would have been won. So make sure you are utilizing the ammunitions that are available to you. I'm here. I can help you. And at the end of the day, you'll be the one smiling. Okay, so guys, give me a call if you need my assistance. I can't wait to talk to you. I really look forward to helping immigrants around the U.S. and giving them excellent legal representation. This is what I'm here for, and this is what I do 24/7. I know, what you need. So contact me and I will be very, very, very happy to assist you. Mr. Francis Gavin says, useful advice. Thank you so much for re-echoing my sentiments. Well, I'll see you guys hopefully tomorrow. I don't know, maybe next week. I like to come on impromptu sometimes. Sometimes we'll schedule, live videos. So hopefully I'll see you guys soon. Okay, take care of yourselves and be good. Bye-bye.